The shocking truth about encumbrances in Queensland property sales. When selling real estate in Queensland, it's crucial to disclose all encumbrances affecting the property to the buyer before they sign a contract. Some encumbrances are easy to identify because they appear on the property's title, such as registered encumbrance or covenants. An example of this could be a driveway or stormwater easement registered on title that affects the property. However, not all encumbrances appear on title. These encumbrances are known as unregistered title encumbrances. They must also be disclosed to the buyer. A common example of an unregistered title encumbrance is a statutory easement granted to utility providers for essential services like water, electricity, stormwater, drainage, internet, and telecommunications. There is no obligation for the provider to notify the titles office, and therefore it's an unregistered encumbrance. The current Queensland REIQ contract for houses and residential land highlights the seller's obligation to disclose matters under the section titled Matters Affecting the Property. This section specifically instructs sellers to disclose all title encumbrances which will remain after settlement, for example, easements on the title and statutory easements for sewerage and drainage, which may not appear on title. Failure to disclose unregistered title encumbrances can have serious consequences. The buyer will likely have the rights to terminate the contract at any time before settlement, even if it's otherwise unconditional. This is noted specifically in Standard Term 7.7 of REIQ contracts. The buyer may also seek damages, including costs. Some real estate agents attempt to cover these encumbrances by inserting broad catch-all clauses in contracts, such as all statutory easements or encumbrances or rights for water, sewerage, drainage, or other utilities. However, this type of general wording, blanket statements are not sufficient and will almost certainly leave the seller vulnerable with legal consequences. If you look on page 3 of the REIQ contracts, right next to the matters affecting the property section, you'll see a little disclaimer that reads, "Warning to seller. You are required to disclose all title encumbrances which will remain after settlement. For example, easements on title in favour of other land and statutory easements for sewerage and drainage which may not appear on a title search. Failure to disclose may entitle the buyer to terminate the contract or to compensation. It is not sufficient to state refer to title, searches will reveal, or similar." If you haven't seen that little section, you should give it a read. Therefore, guys, to ensure full disclosure of any unregistered title encumbrances, sellers should go beyond a standard title search and conduct a free dial before you dig search. This will help identify the exact location of any underground services that may be subject to statutory easements. Third-party town planning reports are also available, like a prop check or a develo. At Empire Legal, we use prop check reports. If it is available in the local council our clients are purchasing, we order a prop check valued at $49 and give it to our clients for free as part of our service. This allows the clients to see any easements or encumbrances that may affect the property. The prop check is in fact a lot more in-depth, offering flooding advice, heritage, koala habitats, fire risk, noise, corridors, odour corridors, etc. We'll put a link in the blog to prop check if you want to check it out. If any easements or encumbrances are found, the seller must mark yes on page 3 of the contract where it asks, title encumbrances, is the property sold subject to any encumbrances? The encumbrance should be then clearly described. For example, sewer main traversing the property, see attached asset map titled Annexure A. Then, a copy of the search with a plan highlighting the encumbrance should be attached to the contract with all parties signing it as part of the agreement. That way, it's unambiguous as to the particular encumbrance we're talking about, and the buyer can't later claim they didn't know it existed. By being compliant and disclosing any encumbrances that might affect the property, a buyer is informed as to exactly what they are buying. This transparency safeguards the purchase as the buyer is purchasing the property with the knowledge of the encumbrance. While some items are considered buyer beware in Queensland, encumbrances are required to be disclosed. Failure to disclose can allow a buyer to terminate right up until settlement. Well guys, I hope you learned a thing or two about disclosing encumbrances for Queensland property contracts today. Keep in mind we have a huge overhaul of the Property Law Act coming into effect on the 1st of August 2025. This will change the way disclosure happens in Queensland, similar to the southern states. If you haven't already checked it out, I've done a blog on this new disclosure regime and the new Form 2, which is a 7-page form that's required as at 1st of August. I'll put a link in the blog. At Empire Legal, we are property experts. It's all we do. If you're buying or selling in Queensland, we are your people. We have thousands of Google reviews with a 5-star average. Pick a conveyancing team you can trust. Like, subscribe, and share. Guys, if you've been listening to this channel for a while, or you've just come across it, but you've never liked, commented, or subscribed, please do. It helps the algorithm find us, which allows us to reach and help more people. Thanks, guys. I hope this helped you out. We'll see you next week. Ladies and gentlemen, please keep in mind that all advice is general in nature and does not constitute legal advice. This is authorised by George Souris Empire Legal, Gold Coast, Queensland, Australia.